does crop up at LLB level, but it tends to appear in LLM modules, such as those devoted to international financial transactions. So what I've tried to do in this presentation is blend the two approaches, one in the field of public law and another in the field of international financial transactions, with a view to showcasing, if that's the right verb, two of the main drivers of what I would call, and what others have called, responsible populism. Now, I'll define what I mean by that a little bit later on, but what I want to begin today's presentation with is a focus on these two concepts, maladministration and corruption. Why? Well, there are two main reasons, among others, but the two main reasons are, firstly, that these are serious problems that appear to be endemic across the world, including the sovereign states or semi-sovereign states that belong to the European Union, and those such as the United States and the United Kingdom, which are outside the European Union but portray themselves as liberal democracies. The second reason why I'm going to focus on these concepts, particularly corruption, is because they are drivers of popular antipathy towards established elites. And that antipathy is, to a considerable extent, justifiable. And the challenge that those of us who who are sympathetic to populist movements around the world is to try and channel the antipathy towards established elites in a direction that is consistent with democratic values and the framework that is provided by the rule of law. So I'm not instinctively sympathetic to the knee-jerk hostility to populism exhibited by senior figures in the European Union and in certain governments around the world. But I do understand the dangers associated with what we might call irresponsible populism, which could be a fuel to the fires of extreme nationalism and communalism and violence. So that my effort today, as with last year's effort, is to try and paint populism in a much more positive light, and to encourage those who are drawn towards populist movements to hem in their antipathy towards established elites, but to ensure that their opposition is conducted in a just, fair, and lawful manner within the constraints of any democratic society. I'm going to draw upon various works in the public domain. I'm not giving legal advice in this presentation, but I do have to begin, before I move on any further, with a declaration of interest. I have one foot in the United Kingdom as a London-born UK citizen, and a second foot in the European Union as a citizen of the Republic of Cyprus, and thus as a citizen of the EU. Now, I've ended up securing confirmation of Cypriot citizenship after a long and laborious process that has given me a clear insight into how far the Republic of Cyprus is bedeviled with maladministration, and my own personal experiences are one of the reasons why I've acquired a particular interest in the concept of maladministration. Now, what is the relevance of maladministration to corruption? Well, it's a driver, or a potential driver of corruption. I'll just draw your attention briefly to the definition of maladministration. In English law, there is no statutory definition of maladministration, but case law offers us an insight into what it boils down to. And in a Court of Appeal case from 2000 involving Liverpool City Council, Lord Justice Henry cited the approach of Lord Denning, the then Master of the Rolls, in a case from 1979. And for his part, Lord Denning, who was the senior judge in that case, referred to Professor Wade's book on administrative law. And Lord Denning, therefore, approved the approach to maladministration as covering concepts such as bias, neglect, inattention, delay, incompetence, ineptitude, perversity, turpitude, arbitrariness, and so on. So that's obviously a fairly broad definition, and it doesn't cover expressly every single form of behavior that may fall within the definition of maladministration, but it does capture some of the features of behavior, particularly in the public sector, that are capable of falling within the definition of maladministration. And the ones that I've experienced in my dealings with the various public bodies in the Republic of Cyprus are neglect. In other words, one makes an application to do something or to obtain something and nothing happens. Delay. Well, the application is made, it's accepted, a receipt is given, but then nothing happens. Incompetence. Well, that might arise if the application is lost, or if the application to obtain document A results in the production of document B, which wasn't asked for. Ineptitude, which is closely connected to incompetence, perversity, turpitude, arbitrariness, and so on. Now, when you're confronted with a public sector that doesn't function effectively, or a public sector that is mired in these sorts of behaviours, partly through underfunding, partly through a lack of meritocracy, which has resulted in the wrong people being appointed to jobs because they happen to have the right connections in the right political party, or they have a relative who's a decision maker who's made a decision based upon the relationship with the person making the application for the job. You end up having maladministration, and therefore the fertile breeding ground for corruption to flourish. In turn, that begs the question as to what is meant by corruption. Now, this is a much more difficult concept to consider, particularly from the standpoint of English law and international law, because we don't have any statutory definition from the point of view of English law, and we don't have any definition of corruption in the United Nations Convention Against Corruption, which dates back to 2003. Let's begin with the Oxford English Dictionary definition of corruption, and this was helpfully drawn attention to by the Law Commission, which is a public body in the UK that's devoted to law reform. The Law Commission explained that according to the Oxford English Dictionary, the verb to corrupt has a number of meanings, of which the most relevant for our purposes is to, quote, destroy or pervert the integrity or fidelity of a person in his discharge of duty, to induce to act dishonestly or unfaithfully, to make venal, or to bribe. Similarly, the adjective corrupt means, among other things, perverted from uprightness and fidelity in the discharge of duty, influenced by bribery or the like, venal. And an act is corruptive if it has the quality of corrupting or tends to corrupt. So corruption, it has a fairly well-established dictionary definition, and it's sufficiently broad to capture, on the one hand, certain types of conduct, such as the giving or receipt of bribes, that falls within the ambit of criminal law. But on the other hand, the definition of corruption, or dictionary definition of corruption, is sufficiently broad as to capture certain types of conduct that are not necessarily criminal, but may nonetheless give rise to a breach of, say, public law in the public sector of a particular country. I'm going to focus on England for the moment because I'm looking at English law. So that's a very important point to bear in mind. Corruption can cover both certain types of criminal behavior, but also certain types of non-criminal behavior that are nonetheless unlawful. It's possible that certain types of behavior may also be unethical and therefore give rise to a breach of a code of professional conduct, but not necessarily give rise to either criminal proceedings or civil proceedings. So the concept of corruption is quite an elastic expression. If you want to take a closer look at the Oxford English Dictionary definition of corruption as it currently exists, or as it existed when I looked at it last year, there we see that the origin is from a Latin word, which is corrumpere, the Latin verb or noun which is associated with corruption. The definition itself, the current definition, is perversion or destruction of integrity in the discharge of public duties by bribery or favour. By bribery or favour. So the bribery, which is what's portrayed on the screen there, the giving and receipt of a sum of money or some other item that induces the improper performance of behaviour, is not the only potential source of corruption. Another potential source of corruption is if no money is exchanged, but there is an exchange of favours. One person promises to another person to do something, and in return the other person does something, and benefits are exchanged, but the benefits do not necessarily involve any sum of money. So I go back to what I was saying a moment or two ago. The term corruption is quite elastic, and it can encompass various different forms of behaviour, not just bribery, which is the most common form, the most well-known form of corruption. You will see here from the United Kingdom government's anti-corruption strategy for the period 2017 to 2022 that there is no universally accepted definition of corruption. But as far as this strategy is concerned, the concept is generally understood to involve the abuse of office and position to benefit a third party, such as an individual, business or other organisation, in return for payment or other reward. These features are captured in Transparency International's definition, the misuse of entrusted power for personal gain. Now, in that definition, there is an implicit acknowledgement that corruption is capable of afflicting both the public sector and the private sector. Corruption tends to be associated with the abuse of public office, but it's possible, for example, if a company director accepts or receives a bribe, for there to be corruption in the private sector as well. And we know enough corruption scandals in both the public and the private sector to know the truth in that assertion that I've just put forward. So corruption is inherently capable of afflicting both the public and the private sectors. The damage, of course, is potentially more grave if the corruption takes place in the public sector. Now, what do we mean by the public sector? Well, in essence, we mean the three branches of government. The executive branch of government, which is headed normally by a prime minister or a president. The legislative branch of government, namely the parliament. And then, of course, the judicial branch of government. Now, it's exceptionally dangerous for corruption to appear in any one of those three branches of government, but it's particularly dangerous if corruption is prevalent in the judicial branch of government, because the judges are supposed to be the upholders of the law, not the corruptors of the law. But we mustn't forget that underneath these three branches of government, at the top of any country, we have various layers of local government, such as town councils or village councils or parish councils. And we know, again, from multiple cases that corruption is inherently capable of afflicting local government as well. Now, what does this have to do with international law? Well, there is an international law instrument that deals with corruption. It's the UN Convention Against Corruption. It was originally adopted in 2003. The version that's on the screen was published in 2004. And astonishingly enough, the convention does not define corruption. So there's no expressly agreed international definition of corruption in the UN Convention Against Corruption. However, various forms of behaviour are expressly addressed by the convention. So let me just give you some examples. The most obvious example is bribery in the public sector and in the private sector. So the UN Convention Against Corruption may not define corruption, but it acknowledges the existence or potential existence of corruption in both the public and the private sector through the granting or receipt of bribes, hence the emphasis it gives to bribery. Then we have the theft type category of corruption: embezzlement, misappropriation, or other diversion of property by a public official, and there is an equivalent provision to do with embezzlement in the private sector. So this is to do with straightforward stealing of money and related activities that the convention refers to as embezzlement or misappropriation or other diversion of property. Then we have in Article 18 the interesting concept of trading in influence. This is a more subtle form of corruption where the system of patronage is abused for corrupt purposes, and therefore somebody is potentially buying or selling positions in the public sector or offices in the private sector through improper means. Abuse of function, which is a variation of the concept of abuse of power, is also in the dealt with in the UN Convention, and the laundering of the proceeds of crime and the concealment of the proceeds of crime are also built into the convention. Now, I'm going to just enter a caveat here. I would suggest that the laundering of the proceeds of crime is in a different category of law, namely anti-money laundering law, and it's the natural consequence of the payment or the receipt of a bribe or other corrupt payment. And it's a necessarily inherently corrupt activity. But I think for conceptually, it's important to treat money laundering, which I'm going to focus on later on today, but it's important to treat money laundering as a consequence of corruption rather than as an integral part of corruption. I hope I've made myself clear. The reason I'm doing that is because money laundering has its own related but separate area of law, particularly in the context of English law. Now, there's a clear overlap between corruption on the one hand and money laundering law on the other. But one of the main differences, and this is the point that I really want to emphasize, we have a clearly defined and a recognized area of legislation specifically devoted to money laundering, at least in England. And therefore, it's sort of slightly detached from mainstream anti-corruption law. I'm going to explain what I mean in a moment or two. Now, I won't go through every single slide, but I just want to draw your attention to what the then UN Secretary General said in his introduction to the UN Convention. And this links back to my argument that maladministration and corruption are drivers of populism and antipathy towards established elites, and why it's so necessary for that antipathy to be channeled in a responsible and ethical and lawful direction. So this is what the Secretary General said. Corruption is an insidious plague that has a wide range of corrosive effects on societies. It undermines democracy and the rule of law, leads to violations of human rights, distorts markets, erodes the quality of life, and allows organized crime, terrorism, and other threats to human security to flourish. This evil phenomenon is found in all countries, big and small, rich and poor, but it is in the developing world that its effects are the most destructive. So the very foundations of any democratic society are at risk of being eroded or completely undermined by corruption. I'll just give you a couple of very obvious reasons. Firstly, if the three branches of government are corrupt, there can be no confidence whatsoever in those three branches of government acting in the best interest of the people, because the corrupt people in the three branches of government will, by definition, be acting in the best interest of the corrupt. And a second very obvious reason, but it needs to be stated, is that if you have a corrupt society and a corrupt set of branches of government, basic principles such as meritocracy and fairness and equality before the law are rendered meaningless. So the adverse consequences of having corruption in one, two, or three branches of government, or further down in the town councils, in local government, and in the private sector, are absolutely enormous. The UN Convention has a number of noble aspirations, and the question is to what extent these have applied in practice across the world. The Article 1, which is referred to as the Statement of Purpose, identifies a number of purposes underlying the convention. The purposes of the convention are: A, to promote and strengthen measures to prevent and combat corruption more efficiently and effectively; B, to promote, facilitate and support international cooperation and technical assistance in the prevention of and fight against corruption, including in asset recovery; to promote integrity, accountability and proper management of public affairs and private property. And it goes on to place an obligation on each state party to the UN Convention Against Corruption to develop and implement or maintain effective, coordinated anti-corruption policies that promote participation of society and reflect the principles of the rule of law, proper management of public affairs and public property, integrity, transparency, and accountability. Now, I'm going to just ask a question here to the members of the audience. I don't know how many there are in the audience, but on the one hand, the convention places an obligation on all of the state parties, which in practice means virtually every state on the planet Earth, to develop and implement or maintain effective, coordinated anti-corruption policies that promote the participation of society. I'm just going to put this as a question. How many people in the audience remember being invited by their government to an anti-corruption event?
Yeah, zero.
Yeah, I don't think so.
I've made my point.
Klearchos, before you proceed,
yes,
surprisingly, not a criticism, but more like a point that might help you make this claim a little bit clearer. I think you've made a very good argument in terms of approaching corruption legally. So how do we understand corruption in law? In political theory, there's been another kind of separate attempt to look at corruption in different ways. So in political theory, corruption is distinguished between two elements. There's the kind of conventional corruption that you described here, and they also identify what they call institutional corruption,
yes,
which is treated differently. So on one hand, on this sort of personal corruption, we have an official who takes bribes, and by their action, by their corrupt activity, the entire institution is put in a bad light, and therefore trust is declining in the institution. But when we talk about institutional corruption, that might be about the function of an entire institution. Maybe they go beyond their powers. Maybe as an institution, they are susceptible to external forces that shouldn't have been influential in that respect. So I think that your overall argument that I understand you're trying to make, that corruption and maladministration drive populism, would be strengthened by incorporating those other dimensions of corruption. Because in my view, that sort of institutional corruption is an even stronger driver of populism because it has a greater systemic effect on trust in institutions and trust in a polity and trust in political arrangements and so forth.
Thank you for those comments. And in a way, I'm going to come to that line of argument a little bit later on for reasons which will become self-explanatory. Are there any questions at this stage before I go on? Perhaps it's an opportunity for anyone in the audience to raise a question.
Again, same as yesterday, if anyone has any questions, you are free to write them in the chat. I'll be monitoring the chat. If anyone wants to say something, you can activate your microphone and talk to Klearchos. I'm sure that he's happy to take any and all comments and questions.
Very much so. Thank you, Andrea. Let me just go back to England and just put some meat on the bare bones of this analysis. In England, as I said earlier, and as the UK's anti-corruption strategy recognises, there is no general criminal offence of corruption. Instead, we have various individual types of offences that are corruption related, but not called corruption as such. And what I've tried to do on this slide is summarise or draw attention to some examples of what we mean by criminal offences that are manifestations of corruption, but not necessarily called corruption. So for the most obvious example is an offence of bribery contrary to the Bribery Act 2010. We have also the very interesting criminal offence known as misconduct in public office. That's a common law offence. In addition, a fraud contrary to the Fraud Act 2006 may constitute an act of corruption, although it won't be charged as corruption, it will be charged as a fraud. In addition, we have acts of parliament such as the Theft Act 1968, which is designed to deal with embezzlement or false accounting or straightforward theft of money, whether it's the theft of public money or the theft of private money. And the UK anti-corruption strategy, interestingly enough, describes theft and fraud as well as money laundering as crimes often linked to corruption. But what I've also tried to do on this slide is remind everybody that we tend to associate corruption with crime, but it's possible for a form of behaviour to be in substance corrupt, but not necessarily give rise to a criminal offence. It might nonetheless still breach civil law. So, for example, an abuse of power, which does not necessarily give rise to a theft or a fraud, may nonetheless activate a claim in breach of contract or a claim for breach of trust. That would apply primarily in the private sector. In the public sector, an abuse of power or an alleged abuse of power may trigger a public law claim based on the principle of abuse of power or procedural impropriety. And as far as employment law is concerned, misconduct proceedings may, and in a professional sphere, professional misconduct proceedings may be instigated in response to an alleged act of corruption. So I go back to my very early point. Corruption is an elastic expression which can encompass various different types of behaviour, be they criminal or non-criminal, and be they in the field of public law or private law. And in the case of McGill and Porter, one of the law, this was a case that reached the then appellate committee of the House of Lords, the precursor to the Supreme Court of the United Kingdom. This was a case of manipulation of votes for party political purposes in the city of Westminster in the days when City of Westminster was led by Dame Shirley Porter. And what I liked about this case is that one of the judges, Lord Scott, he drew an interesting distinction between, on the one hand, political corruption, and on the other hand, what he called money corruption. This was a case about political corruption. I'm reading here from the judgment of Lord Scott. The corruption was not money corruption. No one took a bribe. No one sought or received money for political favours. But there are other forms of corruption, often less easily detectable and therefore more insidious. And in this particular case, the improper activity that was under the spotlight and exposed was gerrymandering. That is to say, the manipulation of constituency boundaries for party political advantage, and Lord Scott determined that that was a clear form of political corruption. So that's another interesting little distinction here. And the message I want to bring across to the audience is, as a result of this case, one mustn't think of corruption solely in terms of the grant or receipt of a bribe, even though that's the most obvious type of corrupt behavior. There are various other types of corrupt behavior that, in the words of Lord Scott, are less easily detectable, but equally more serious. Money laundering, very simply, according to the explanatory notes to the Proceeds of Crime Act 2002, is the process by which the proceeds of crime are converted into assets which appear to have a legitimate origin, so that they can be retained permanently or recycled into further criminal enterprises. Now, the grant or receipt of a bribe in England would fall foul of the Bribery Act 2010, but if the bribe is indeed a bribe, then the bribe would constitute criminal property for the purposes of anti-money laundering law. So go back to my distinction of a few minutes ago. The grant and receipt of the bribe under English law would activate a potential offence or an actual offence under the Bribery Act 2010, but by virtue of it being a corrupt sum of money, the bribe will simultaneously activate a breach, or potentially activate a breach, of the Proceeds of Crime Act 2002, and therefore bring anti-money laundering law into play. And what this image that the Home Office and a number of other bodies have issued tries to do is show that corruption through, for example, bribery, can form part of what it calls the web of crime. I'll just give you a very simple example of what this image means in practice. Let us say you have a drug trafficker who trades in illegal narcotics, and through selling illegal narcotics, the drug trafficker has a sum of dirty money. The drug trafficker then goes to a border control officer and, with that dirty money, bribes the border control officer to enable the drugs to slip through the border. In that situation, you end up with three types of crime. You begin with the drug trafficking offence, which has given rise to the dirty money, contrary to anti-money laundering law. You then have the handover and receipt of a bribe. This is where the border control officer comes in. That gives rise to a second crime of bribery and the anti-money laundering offence that flows from that. And thirdly, you have the anti-money laundering side to this equation in its own right. So that's what I'm trying to bring across in this presentation, that there is not necessarily one approach to corruption. Corruption can give rise to a number of different manifestations. And this is just an obvious point that a money laundering transaction may involve not just the transfer of cash, but also the transfer of money by electronic means, gold, works of art, shares, and so on. And there are three, just to close the discussion on money laundering, there are three main stages: placement, layering, and integration. Now, I'm just going to pause there before I come to Mr. Blair and Mr. Putin. Are there any questions on my analysis of the law as far as England is concerned, and as far as the international law is concerned, the UN Convention Against Corruption? Should I just pause there? Are there any questions? I'll take that as a no.
No. Glenn, I think the legal analysis is clear. I do have some comments, but I'm sure that they will come up later. once you start linking this to populism.
Thanks, Andreas. I'm going to just go back a bit, and I'm going to now draw your attention to my main argument. Can you just hold the line for me to just... Can you just hold the line, Andreas? I've just got to reconnect the electricity. Can you just bear with me 1 second?
Sure, no problem.
I was on the battery function. I just didn't want the battery to run out, so I'm now plugged into the electricity. Right. Here's my my argument. You mentioned systemic, institutionalized corruption earlier, Andrea. But this is where I'm heading. What we've had over the last 30 years or so, since the collapse of the Berlin Wall, the disintegration of the Soviet Union, and the emergence of the Russian Federation, has been the emergence of a systemically corrupt state of affairs across much of the world, but particularly in the two countries that I know exceptionally well. One is the United Kingdom and the other is the Republic of Cyprus. This has given rise to a disaster for ordinary people. And I'm thinking here of ordinary Russian people, ordinary British people, ordinary Cypriot people, and everybody else who is blameless and has not been tainted by this systemic institutionalized corruption. Now, what do I mean by this? I'm going to use this as a case study to make my point. Before Russia reinvaded Ukraine on the 24th of February 2022, I've used the verb reinvaded because we mustn't forget that there was a previous invasion in 2014. Before Russia reinvaded Ukraine on the 24th of February 2022, the governments of the UK and the Republic of Cyprus cultivated close ties to Russia, while appearing to turn a blind eye to clear evidence that Russia was the original source of many corrupt or otherwise dirty funds that were pouring into the UK on the one hand and the Republic of Cyprus on the other. Now, I'm going to draw attention to a number of House of Commons reports that have drawn attention to this and have warned about this, but didn't really cut much ice when they should have done, which was well before the events of the 24th of February 2022. An illustration of this pouring of money is the renaming, the redubbing of London as Londongrad. I mean, that's not an official name, but it's what it's come to be known as in this context. And in the Republic of Cyprus, Limassol has been rebranded or recharacterized as Limassol Grad. Grad, I understand, being a Slavic word to denote a city or a town. It's interesting that there are differences between the two, but in substance they boil down to the same thing. London attracted a lot of dirty or corrupt Russian money through the golden visa scheme operated by the UK government. The Republic of Cyprus attracted a lot of corrupt or otherwise dirty money because of the golden passport scheme that became discredited. So it's a slight difference. In the UK, we had the golden visa scheme. In the Republic of Cyprus, we had the golden passport scheme. But what they boiled down to were schemes that were designed to make it easier for exceptionally wealthy people to invest in the two respective countries. Now, there was a logic to this, because if a wealthy foreign investor invests in a country, that's good for the country in the sense that it enables money to flow through the system, taxes to be paid, jobs to be created, opportunities to be generated, and so on. The problem was that in both cases, the schemes were exposed to the risk of I'm going to choose my words carefully because many of these people have not been charged or found guilty, but people with questionable backgrounds were let in when they perhaps shouldn't have been let in. And this is one of the problems we have in this area of law, because the corruption appears to have become systemic and institutionalized. It's exceptionally difficult to find court judgments and successful prosecutions, and therefore sentencing remarks, which lay bare the nature of these schemes or scams, depending upon which way you look at it. So that's my case study to illustrate systemic or institutionalized corruption. And the problem with this is that we are now, as a consequence of the failure of these past policies and practices, we're now at the early stages of a severe economic backlash. Russian money that used to go into the UK and Cyprus is now going to dry up. The extremely aggressive anti-Russian sanctions, which are arguably justifiable, but they are aggressive, they are going to have a detrimental effect not just on ordinary Russian people, but on ordinary people around the world, partly because of the disruption in trade going in and out of Russia. The tourism industry of Cyprus is going to suffer enormously, because whereas in the past Russian tourists were a major source of tourists, those tourists are going to go elsewhere. The question arises as to whether the economic devastation that has been caused already and will be caused by the failure of these policies is going to give rise to populist movements of the wrong sort, if I can use that phrase. Extreme nationalism, extreme hostility. That's the question. I don't have the answer to my question, but I'm going to suggest to you that the policies of the past and the practices of the past have backfired with dire consequences, and this is of relevance to your conference on populism. Now, I'm just looking at the clock. It's approaching 10 o'clock, so I'm going to maybe speak for another 15-20 minutes or so, Andreas, and then I want to throw the floor open to discussion. But let me just explain to you in a little bit of detail what happened in the past and what went wrong, and I'll try and do a comparative analysis with both the United Kingdom and the Republic of Cyprus. Let's begin with the United Kingdom. And as you can see from these two photographs from the Kremlin, when Tony Blair was Prime Minister of the United Kingdom from 1997 until 2007, the United Kingdom enjoyed a reasonably good relationship with Russia. It was not perfect. It had its bumps, but it was very much a relationship that was an evolution from the previous relationship that the United Kingdom enjoyed, and I think enjoyed is the correct verb, with Boris Yeltsin, when Boris Yeltsin was in charge in the Kremlin, or perhaps not in charge is the wrong verb, because he did enjoy a drink or two. He was in office. And so what you see in these photographs is a pretty reasonable relationship between Russia and the United Kingdom. I mean, this is to the good. We want good bilateral relations across the world, and we want peace and prosperity to prevail. But this was the era when what appears to have been corrupt or otherwise dirty money started to pour in to the United Kingdom. It started to pour into the United Kingdom during the 1990s, during the Yeltsin era, but it appears to have gathered pace during the Tony Blair era. And the problem was, as the House of Commons Foreign Affairs Committee has reported or alleged, eyes were closed. Eyes were closed. as this dirty or otherwise corrupt money was pouring into the United Kingdom during the Blair years. What I've done on this next slide is show you the souring of the relationship through the face of Theresa May when she was Prime Minister. So that's a photograph taken in Japan at the G20 summit on the 28th of June 2019, and Mrs. May, the then Prime Minister, did everything she could not to smile, as if to show her dissatisfaction with Russia for various different reasons. So the relationship with Russia began to break down well before the invasion or reinvasion of Ukraine on the 24th of February 2022. However, and this is the criticism that's been levelled at successive governments in the United Kingdom, namely those of Prime Minister Blair, Prime Minister Brown, Prime Minister Cameron, Prime Minister May, and now Prime Minister Johnson, the UK government didn't, and the law enforcement authorities did not take adequate steps to prevent the penetration of the United Kingdom by Russian money of questionable provenance. This has also given rise to this, I have to use the phrase, informed speculation and fragments of evidence that Russian money has been used to fuel what you might call populist movements or populist organizations in the United Kingdom. There's mounting evidence of that, but the evidence is not compelling enough to have resulted in any criminal prosecutions, or at least criminal prosecutions of which I'm aware of. I now take you to the House of Commons Committee report published in 2018 called Moscow's Gold, Russian Corruption in the United Kingdom. Now, I want to just spend 5 or so minutes on this report. I'm going to encourage you all to read it. I'm giving you a hyperlink to it, and I'll make sure that these slides are given to the attendees after this presentation. But I just want to read to you what the House of Commons Foreign Affairs Committee reported on in 2018. This was a devastating critique of the then UK government of Theresa May, but it was a reflection of a much wider problem that went all the way back to the Tony Blair years, in fact arguably going even further back to the John Major years in the 1990s. The UK government responded robustly to the attack on Sergei Skripal and his daughter Yulia in Salisbury in March 2018 that was attributed to Russia. But despite the strong rhetoric of the UK government, President Putin and his allies have been able to continue business as usual by hiding and laundering their corrupt assets in London. I have to say here, the UK House of Commons Foreign Affairs Committee has exercised parliamentary privilege by making that allegation, and I'm shielding myself behind that parliamentary privilege in echoing the allegation. But that was the allegation that they made, that President Putin and his allies have been able to continue business as usual by hiding and laundering their corrupt assets in London. These assets, on which the Kremlin can call at any time, both directly and indirectly, support President Putin's campaign to subvert the international rules-based system, undermine our allies, and erode the mutually reinforcing international networks that support UK foreign policy. This has clear implications for that is to say the UK's national security. Turning a blind eye to London's role in hiding the proceeds of Kremlin-connected corruption risks signalling that the UK is not serious about confronting the full spectrum of President Putin's offensive measures. That is a devastating criticism from an all-party committee that had undertaken an investigation into the extent to which Russia had penetrated the United Kingdom. And the details are in the report. But what it does suggest to me is that there has been a multi-dimensional Russian penetration of the United Kingdom, most obviously the penetration has taken place in the economic sphere, but it has also had effects in other spheres, including, it would appear, social media, other forms of media, and the other facets of UK life that we take for granted. Now, the report lays considerable responsibility at the door of the then Foreign Secretary Boris Johnson, who's now, of course, Prime Minister. Robust rhetoric by robust rhetoric by the then Foreign Secretary Johnson is somewhat undermined by, as Transparency International argued in evidence to us, London remaining a top destination for Russian oligarchs with links to the Kremlin to launder proceeds of corruption and hide their assets. And the report goes on in a similar vein. I won't tie you with the details other than to draw your attention to the admission by the National Crime Agency that many hundreds of billions of pounds of international criminal money is laundered through UK banks, including their subsidiaries, each year. And that's an eye-watering sum. Many hundreds of billions of pounds of international criminal money is laundered through UK banks, including their subsidiaries, each year. Much of that money, it would appear, originated in Russia, and some of it appears to have entered the UK via various routes, including the Republic of Cyprus. If this is not institutionalized or systemic corruption, I don't know what is. Andreas, do you want to come back to me on that point?
I do, yes.
Go ahead.
I understand what you're trying to say here, but at the same time, it seems to me that there's a strong individual corruption component here, in the sense that it is still strong individual agents who wield significant political power, and they seek to use that political power in ways to further their sectional interests. And I mean, I'm not very familiar with the English case you're making here, but in Cyprus, it seems to me that it's a combination of personal and institutional corruption in the following sense.
Yeah.
There's obviously a personal component, right? Certain agents at specific positions, oftentimes very powerful positions, right? In Cyprus, we had the president of the parliament resigning due to the citizen by investment scheme. And so it's powerful agents who exercise their political power for sectional interest. So that's clearly one side of the coin, and I by no means dispute that. The institutional corruption, on the other hand, seems to me to require us taking a step back and looking at the way the institution is set up that gives those opportunities to agents to do whatever that they go on doing. And I suspect that this is what you're gesturing towards here when you talk about institutional corruption in the case of the UK, that there are some systemic problems in the way the institutions function, but provide opportunities for specific agents to proceed with corrupt activities, or in this case, hiding corrupt activities.
Andrea, that's very helpful. I'm actually going to go on and identify one or two examples of causes of the institutional systemic corruption. But I take your point, and I think it's a valid one, that there are both personal as well as institutional factors at play. In fact, you have a synergy between the two. That synergy produces a an even worse outcome that would otherwise be the case if we just had one personal criteria or just the other systemic criteria.
And I think, so to pick up on this point, I think that it's not enough to point out that there is corruption here. Because the danger of simply pointing out corruption is to suggest that the common argument, right? A few bad apples, that you have some agents that exploit their power for sexual interest. But it's not just that, because responses to personal corruption are clearly different from responses to institutional corruption. Because a response to personal corruption might be the use of a legal mechanism. It might be the case that, oh, we simply bring an action against the corrupt agent, remove them from office, or hold them accountable. Maybe it's a criminal case, maybe it's a civil case, as you pointed out. But the problem is that there are not legal remedies to tackle institutional corruption. It's not like you can bring an action against the parliament as a whole or against the executive as a whole.
That's a very good point.
So institutional corruption requires extra legal action. That might be political willingness to do something, or it might require political action at the individual level, so sort of grassroots protest, which we have seen in the past. And this is where populism kicks in, right? Because many of those protests where they employed populist discourse, right? They talked about, oh, the politicians being corrupt. Along the lines, the message is lost, but the feeling is there, the lingering belief that there is institutional corruption that is unable, whereby institutions are unable to carry out their ordinary functions, they are unable to promote the common good, and instead they cater to specific sexual interests.
Andreas, if I just pick up on that, let me just go to this. Here we go. There's two features of the report that interlink with our discussion. The first is here, and this was written in bold in the original text. The use of London as a base for the corrupt assets of Kremlin-connected individuals is now clearly linked to a wider Russian strategy and has implications for our national security. Now, I'm going to merely speculate here, but I follow a number of what you might call populist movements, and I've noticed that some of them, I'm not going to mention any names, partly because of the law of defamation, but I've noticed some populist movements appear to be overly friendly towards Russia and overly supportive of Russia and overly sympathetic to the Russian case in Ukraine. I mean, I take the view that one should be critical of both Ukraine and Russia, but the evidence is clearly suggesting that the weight of responsibility lies with Russia. But there's clearly mounting evidence that certain Ukrainians are responsible, for example, for war crimes or crimes against humanity. And that's why we do need a fearless and independent investigation from the prosecutor at the International Criminal Court in The Hague. So I take a sort of a more balanced view, but I've noticed some of these populist movements are overly sympathetic to Russia and say next to nothing about the alleged war crimes that have been committed by Russia or Russian forces. Now, the question arises, how many of those populist movements that are sympathetic to Russia are taking Russian money or money that's connected to Russia? And if they are taking money that's connected to Russia, is that money influencing their editorial approach to various questions? I don't know the answer to that question, but I have noticed that, and some of you in the audience may have noticed that as well. We can have a discussion on that. But this is what the House of Commons report was driving at, in part, in its report of 2018. The second thing that I wanted to draw your attention to from the latter part of the report is this goes back to systemic problems, Andreas. This is to pick up what you were saying earlier. The House of Commons report tried to find out why there was insufficient action being taken against this practice of this industrial scale practice of pumping hundreds of billions of dirty monies into the British economy every year through the banking system. And they quoted here, this is the House of Commons report, Vladimir Ashurkov of the Anti-Corruption Foundation, who told the committee that the Serious Fraud Office, which is one of the main law enforcement agencies in England, remained understaffed and under-resourced, and that he was not receiving responses after bringing cases to the SFO's attention. I mean, it's quite a serious allegation. And this is the quotation that's reproduced in the House of Commons report. I think there are several reasons why the Serious Fraud Office and other regulators in Britain turn a blind eye towards Russian corrupt money flows. One is they do not have enough resources, monetary resources, staffing resources, etc. There's also a perceived need to get evidence from Russia if they are investigating a particular case of corruption, which may not be true. And there is no real political will to go after corrupt money flows. Maybe it will change in the current political situation. They can expect that the billionaires whom they will investigate will hire the best legal help available. And would the Serious Fraud Office want to compete with the best lawyers? So on balance, I think they decide it's not very economical to pursue such cases. That's obviously an allegation, and the Serious Fraud Office would counter it. But it reflects the perception that one of the systemic problems associated with the or inadequate response to these massive flows of corrupt or otherwise dirty money is the understaffing of law enforcement agencies. I don't know whether that's the case in the Republic of Cyprus, but the pandemic, or perhaps some might say the unreasonably aggressive response to the pandemic, has resulted in even more economic miseries that are going to result in even more budgetary pressures placed on bodies such as the Serious Fraud Office and its equivalent in the Republic of Cyprus. I just want to finish with just a few minutes on I've got in the interest of fairness, I should refer you all to the government response to the committee's report, which you can read on the UK Houses of Parliament website at the link at the bottom. The other report that I haven't got time to look at, but I would encourage everybody to read, is the...
Just a minute,
yeah.
we have a comment here.
Yes, please.
Okay, COVID, social distancing. Thank you, Klearchos. Thank you, Andreas. So I was listening very carefully and trying to perhaps, draw some comparison with what is happening. Okay, so here we have a comment about Hungary. I was going to get back to France, actually. So both Hungary and France are actually examples of countries that went through public elections recently. And at least for the French example, I wanted to come back to, how the discussion on corruption and illicit activities and illicit monies invites itself into the public discourse during elections. So, for example, during the presidential elections in France that took place just a couple of months ago. And while, of course, the implications and the consequences of organized crime activities are very visible in the business sector, in the wider business sector, they're also visible in public life. And that is potentially one other area where we could link populist trends with corruption and other illegal activities. I mean, I can only give one example, which is, I think, very striking, and of course it's in the public domain, so I'm not going to be sued for anything. When President Macron, outgoing President Macron, during the debate between him and the presidential candidate for the second round, Marine Le Pen, actually reminded her that when she talks about Russia, she's talking to her banker. And that kind of very polarized statement, not to say anything else, actually, reveals or brings to the surface the political impact and the potential interference of money from proceeds of criminal activities or other illicit activities into political life at the highest possible level. So I think this is another very interesting direction that the research on, the implications of corruption on populist trends or responsive populism could take. I just wanted to, share that. And as I said, there is a comment about Hungary. So let me just pick it up at this point because I think it's actually relevant. Just a second to see. Yes, so it says, what is your opinion on Hungary's opposite position on sanctions against Russia? Okay, so is it also the matter of institutional corruption? So we are back to the distinction between, individual or political corruption or economic corruption and institutional corruption. But I think the example I gave before about France can be repeated if one is going to study very carefully the public discourse in times of elections, particularly presidential elections or high-level elections, and the impact that potential illicit activities have on such elections, not to mention what has happened in the United States in the past few years. Anyway, so I just wanted to contribute this, Claire, at this stage. Thank you.
Well, thank you, Stephanie. Let me deal with that comment first. It preempted my reference here, brief reference to the Intelligence and Security Committee of the UK Parliament that produced a report into Russia. Was covered up essentially. The UK government gave an excuse that they needed a few years to go through it and redact certain portions of it and go through various security checks. Anyway, it eventually came out on the 21st of July 2020, and it in a sense it makes the point that you've just made, but in the Russian context. I'll just read to you the paragraph that caught my attention, paragraph 14. This is an allegation, of course, which Russia would deny, but I have to put it forward. This, by the way, was a committee chaired by Dominic Grieve, QC MP, as he was then known, the former Attorney General, and therefore it was a report that's written in very carefully worded terminology. He'd left Parliament by the time that the report was published. But anyway, this is what it says on the interlinkage between corruption in the public sector and corruption in organized crime. Russia has sought to employ organized crime groups to supplement its cyber skills. SIS, that is to say the UK Secret Intelligence Service, otherwise known as MI6, has observed that, quote, this comes to the very muddy nexus between business and corruption and state power in Russia, close quotes. The UK government communications headquarters told the committee there's quite a considerable balance of intelligence now, which shows how the links between serious and organised crime groups and Russian state activity, and that we've seen more evidence of redacted, serious and organised crime redacted, being connected at high levels of Russian state and Russian intelligence, and in what it, that is to say GCHQ, describes as a symbiotic relationship. So if these allegations are true, and there's considerable evidence that suggests that these allegations may be true, the Russian state is an embodiment of this symbiotic relationship that one has in certain parts of the world between the state on the one hand and serious and organized crime groups on the other hand. Now, as regards the very pertinent question about Hungary, I have to confess that I do not know enough about Hungary to give an authoritative answer, but what I will say is that what we do require in each and every member state of the European Union and the United Kingdom is an independent public inquiry in each of those member states to ascertain the nature and the scale and the consequences of the penetration of Russian dirty or corrupt Russian money into our respective societies. That is going to be something that's more likely to happen in a country such as the United Kingdom, which has a tradition of establishing independent public inquiries, or as you can see here, independent-minded parliamentary inquiries. It's much more likely to happen in the United Kingdom than in certain parts of Europe. And Hungary, I don't know whether they have a culture of independent public inquiries, but they sorely need that. I would suggest that the corruption that has been induced by Russia is one of the main factors that need to be subject to investigation. The other one is the degree to which member states of the EU and to a lesser extent the UK have been dependent on Russian energy supplies. That's another subject for another day I don't want to discuss, but that's been clearly another motivating factor behind the approaches of some member states in the EU to Russia, that their heavy dependency on Russian energy. The intelligence and security report made similar allegations to the ones that were made by the Foreign Affairs Committee. I don't really want to go into this in any detail, but I just want to mention here that the reference to Londongrad is very much prevalent in this report. And the sentence I just want to read to you here might equally apply to what has happened in the Republic of Cyprus. In brief, so I'm quoting here from the Intelligence and Security Committee report. In brief, Russian influence in the UK is the new normal, and there are a lot of Russians with very close links to Putin who are well integrated into the UK business and social scene and accepted because of their wealth. This level of integration in Londongrad in particular means that any measures now being taken by the government are not preventative, but rather constitute damage limitation. Let me just spend 5 minutes on, and therefore what the committee concludes is that the UK authorities are trying to shut the stable door after the horse has bolted. Let me say a few words in 5 minutes on the Republic of Cyprus, or 3 minutes, and I'll try and then I'll wrap up at 10:30 to enable a question and answer session to begin. So in common with the United Kingdom, the Republic of Cyprus has become synonymous with legal as well as illicit flows of people and money from China, Russia and other states which are autocratic, corrupt, or both. And this is a general subject that has been the subject of a very interesting investigation by the United States House of Representatives Foreign Affairs Committee, and it's symbolized by that image that it published on the 9th of May 2019. And the Republic of Cyprus is very much part of the Eastern Mediterranean and this Russian penetration. We've also seen the Russian penetration in the field of nuclear energy. Turkey is constructing a nuclear power station with the assistance of both the Kremlin and the Russian State Atomic Energy Agency at Akuyu, 110 kilometers to the north of Nicosia. And Egypt is constructing a Russian-built nuclear power station on the northern coast of Egypt. So those are just two examples of a Russian penetration into the Eastern Mediterranean in the field of nuclear energy. But as far as dirty or corrupt money is concerned, it's been an open secret for years that the Republic of Cyprus, as well as British overseas territories such as the British Virgin Islands and the Cayman Islands, have been closely connected in global money laundering schemes. And I'm quoting here from the evidence presented by Dr. Michael Carpenter to the House of Representatives Foreign Affairs Subcommittee on the 21st of May 2019, where he made this point. You can read the details in your own time. But the point I'm making here is that for years we've known that, I'm using this phrase repeatedly, so I'll repeat it again. We've known for years that corrupt or otherwise dirty money has been leaving Russia and pouring into the Republic of Cyprus. We've known for years that Russia has been engaging in illegal activity in Crimea. We know for years that together with Turkey, Russia has acquired the worst human rights record at the European Court of Human Rights. And yet, in September 2020, the President of the Republic of Cyprus chose to shower praise together with an award upon the still Foreign Minister of Russia, Mr. Lavrov, whom he called his friend. And this photograph that was published by the Republic of Cyprus on the 8th of September 2020 sums up the systemic, I'm going to use my words carefully, the systemic intimacy of the relationship between Russia and the Republic of Cyprus, despite all of those things that I've just mentioned. If one looks at the annual US State Department investment climate statements for the, we haven't yet seen the statement for the period since the Russian invasion of Ukraine on the 24th of February 2022. But if one looks at, for example, the 2020 investment climate statements, one will see a rather astonishing result. There are 194 or so states, sovereign states dotted around the world. Cyprus comes top of the league table for inward direct investment into the Russian Federation, and top of the league table for outward directed investment out of the Russian Federation. You can see from these statistics published by the US State Department in 2020 that Cyprus is inextricably bound up with the economy of Russia, and vice versa. Russia is inextricably bound up with the economy of Cyprus. But what one also sees in these US State Department statistics are repeated reference to British overseas territories such as Bermuda. Bermuda appears on that list. If one looks at the investment climate statement for Cyprus, as distinct from Russia, one sees a rather similar picture, although Luxembourg has come out ahead of the Russian Federation. And there's also, as you can see there, reference to Jersey and the British Virgin Islands. Jersey being a Crown dependency, the British Virgin Islands being a British overseas territory. Now, much of this money will be legal. Let me just make this clear. Much of this money will be legal, but the question arises as to why Cyprus has ended up at the top of the tree for both inward direct investment into Russia and outward direct investment out of Russia. Why has that happened, and how much of that money is dirty? And of that dirty money, if it's dirty, how much has, to what extent have the authorities closed a blind eye to it? So I won't go through this any further, other than to just to state that those statistics speak for themselves. As I said earlier, I found it very difficult to find UK cases with a Russian and Cypriot dimension built into them. But if one goes to the website of the US Department of Justice, one is spoilt for choice. There is one reported case after another with a Cypriot and Russian dimension to it. And what I've placed on the screen there is just a list of case reports that have been published by the US Department of Justice over the last 12 years or so that refer to both Cyprus and Russia within the same report. Further details on this subject, in other words, on the level of corruption in the Republic of Cyprus and the level of maladministration in the Republic, are in the report into the collapse of the cooperative bank chaired by retired Judge Arestis, who's what we should declare a fellow of our university, and also on the discredited citizenship by investment scheme, there is a report of inquiry by another retired judge, Miron Nikolados. Now, I'll just finish with one quotation. The citizenship by investment scheme was a classic example of systemic corruption in the Republic of Cyprus. The details are in the report of inquiry. All I'm going to do here is just read to you a paragraph from a very useful overview of that report by Louis Garaoulis, as published by the Oxford Human Rights Hub on the 6th of September 2021. After all of this scrutiny and revelations, cue the inquiry report led by Cyprus's former Supreme Court President Miron Nikolados, who submitted a report to the Attorney General's office, though non-binding. In other words, it wasn't a court judgment; it was a report of inquiry. The report, which is heavily redacted due to ongoing investigations, found that a total of 6,779 Cyprus passports were issued during the 13-year rollout of the scheme, and of that total, the committee concluded 53.24% were granted unlawfully, in that they were allocated not to the actual investors but to their relatives and company executives. Pursuant to the report, Nikolados opined that it was obvious the scheme operated with blanks and omissions, without a legal framework and almost without a regulatory framework. That is a classic example of systemic maladministration married to systemic corruption, I would suggest. And the problem that we have is that we are all suffering as a consequence of this, because the part of the Cypriot economy that was built up to cater for this scheme has, to all intents and purposes, taken a hit, and that hit has now been supplemented by the drying up of the Russian money that used to come in on a regular basis. So if I can just draw things to a close, the Russian,
Stephanie actually has a comment on.
Yeah, Stephanie knows a lot more about this than I do, so I'd welcome her comments.
Thank you, Andrea. Thank you, Klearchos. Well, it's just that because we are being recorded and this will go public, I have to declare an interest as well, because I was involved in both commissions of inquiry, the ones that you actually showed, and the most recent commissions of inquiry in the Republic of Cyprus. So I just wanted to put that on record. There are aspects that can be discussed, obviously. The reports are public in any case, but they are in Greek. Unfortunately, so that somehow restricts access to information, and also that they are extremely technical and lengthy reports. So one will have to take the time and make the effort to look into this. And also that the methodology of the reports is very interesting, because those being reports by commissions of inquiry, by definition, a lot of the information was made available and fell into the public domain via various methodologies and processes, which included, for the first commission of inquiry presided by His Honor George Arestis, retired, it included public hearings. Less so in the second one, but in the first one it included public hearings of extremely well-known public figures. Yes, so that's all I wanted to say, and perhaps we can have another webinar just on those reports. That would be very interesting. Thank you.
Thank you, Stephanie. Well, this is all backfired. This is where I want to end. We ended up with this Russian invasion of Ukraine on the 24th of February 2022, and this sort of extremely aggressive reaction by the EU and the UK and the US and other international actors. And these are the maps that have been published by the US State Department, sorry, the UK Ministry of Defence, which show the scale of the hostilities in the region. And it's hardly a surprise, I'll just finish on this point, it's hardly a surprise that if one looks at opinion polls in the EU, that the Republic of Cyprus and Greece and other Eastern Mediterranean actors tend to be towards the the upper end of the spectrum in terms of public perceptions of corruption. So if, for example, one reads the report on corruption published by the European Commission in December 2017, this is before Brexit, of course, I'm going to finish with this slide. While perceptions of the extent of corruption have fallen since the previous survey, almost all respondents in several countries think it's widespread, and particularly in Greece, where 96% of respondents spoke of corruption as being prevalent, as well as in Spain, Cyprus, and Croatia, where the equivalent figure of 94% was applicable. So I think the point that I'm going to finish on is that, here we are, I'll finish on this. The definition of populism in the Oxford English Dictionary is one that we need to take seriously. The definition, this is not the political science definition, but it's the Oxford English Dictionary definition. Populism relates to the policies or principles of any of various political parties which seek to represent the interests of ordinary people, specifically of the populists of the US or Russia. So Russia is right at the heart of the intellectual origins of populism. Populism also means support for or representation of ordinary people or their views. There's nothing wrong with that. In fact, that is the essence of democracy, I would suggest. The problem is, of course, when populism spills over into extreme nationalism or racism or other forms of activity that have harmful consequences on society as a whole or on individual people. And therefore, I've been influenced by a short article, newspaper article, magazine article by an American author called Jamie Fly, who wrote in the Pacific Council on International Policy magazine on the 1st of November 2018 the following, and perhaps I can close with this thought. What is needed to counter the current populist wave is in effect a responsible populism. Leaders who can win not by inciting hate or pitting one side of the political spectrum against the other, but can inspire a coalition willing to tackle shared challenges. He then goes on to make a telling point, which I endorse. Far too many conventional politicians continue to play into the populist hands. Sensitive issues like immigration and cultural changes are regarded as off limits rather than confronted head on. Well, what I've tried to do over the last hour or so is show you that a sensitive issue such as the penetration of corrupt or otherwise dirty money into the United Kingdom and the Republic of Cyprus has been, unfortunately, regarded as off limits. And rather than being confronted head on in the past few years, the problem was left to simmer. And regrettably, with the Russian invasion or reinvasion of Ukraine on the 24th of February 2022, the problem has now boiled over. I end with that thought and welcome your questions and indeed criticisms.
Thank you so much, Klearchos. The work that you're doing is actually very, very important, especially if you can go back to one of the slides where you can actually see the data. So slide 60, for example, that you have in here.
Yeah.
Yes. So that's very interesting. Why is your work so important across, the various research projects? Externally EU-funded research projects we have, for example, at the school, like EU POP, but also the Jean Monnet Center of Excellence, CROLEF. It's because when you touch upon issues related to corruption and organized crimes, but also issues of respect for the rule of law, very often specific countries are absent from the data collection. So the job and the duty of an academic and a researcher like yourself or ourselves is actually to try to make sure that we zoom in and we browse across the world for data. And this is exactly what you've done today. For example, sending us back to a lot of department sources as actually, sometimes being more efficient when it comes to looking at those issues in Europe. And when it comes to monitoring of rule of law indicators, including corruption, frauds, and the like, but not only, also with respect to justice, countries like Cyprus are usually either absent or, the data is not sufficient to be analyzed. So that is one of the things that we're trying to bridge the gap or plug in so that we can somehow via collection of data, scientifically justified and evidence collection of data, try to, bridge that gap and yes, and do something about it. So the examples of data collection that you have included in here are very interesting, and they are, they are varied. But if you had gone, for example, to the European Commission's Justice Scoreboard, which again goes back to a lot of the indicators or traditional, let's say, characteristics of rule of law, democracies and European values kind of survey, you will see that, countries like Cyprus, but not only, and it would be interesting to draw a map, are either performing very poorly or the data is not available. Yes.
And one of the problems we have in the Republic of Cyprus is that if one tries to engage in any form of communication with a public body, it's almost impossible to succeed unless one knows somebody within the public body concerned, in which case, which raises ethical questions. I mean, how can you conduct ethical research if you have to engage in unethical conduct in order to produce the raw material to produce an academic piece of work? If one writes to a public body in the United Kingdom, one has no problem normally in extracting a response. Equally, if one wants to make use of the freedom of information law in the United Kingdom, at least, virtually every government ministry or public body has a part of its website devoted to guiding citizens as to how to make an effective freedom of information request. So they will say to you, please write to our freedom of information officer at the following postal address or email address. That doesn't happen routinely in the Republic of Cyprus, even though we have a new freedom of information law dated 2017 that was brought into force in December 2020. And as I know from my own personal experience, even if one invokes the new freedom of information law when one communicates with a public body or government ministry in the Republic of Cyprus, that's not a guarantee that the public body or government ministry will respond. And that makes it exceptionally difficult to engage in serious academic research in the Republic of Cyprus. And it adds to this problem that you've quite rightly identified.
That's right, Claire. Hence the idea under the Centre of Excellence to actually create our own databases. So via various methodologies such as surveys, but also focus groups and other interactive tools, so as to be able to bridge the gap of missing data. But what we definitely need, and this answers partly probably the question that is in the chat, that is what steps can be taken in order to prevent the pecuniary influence of Russia on Cyprus. What really needs to happen here is the enhancement of the capacity of not only the public services, but also the professional services in Cyprus. So when it comes to professional services in Cyprus, one might say that these are of high standards and high caliber, and that there are many initiatives in the private sector in particular, but also in the public sector, to raise awareness on ethical professional conduct and integrity, and this must be encouraged and this must be further developed. There are codes of conduct, for example. But when you actually think about the smart sanctions against Russia, the latest rounds, so let's start with round one. Well, actually round 1, 2, 3, because they came quite close to each other. The professional services seem to be able to cope with the adjustments that need to be done to the way they do business in the light of those sanctions. What is the problem, though, is that the regulatory framework itself is delayed in countries like Cyprus. So whereas you can see that in countries like the UK, the professional bodies, for example, the Law Society, are taking, regular steps and updating their regulatory framework and communicating it to their members, to say the least. This kind of process is delayed in Cyprus. And we had to wait for about a couple of months before the professional bodies in Cyprus, particularly representing the lawyers and representing the accountants and the auditors, issued a joint statement asking for further clarifications from the national authorities on how to implement those sanctions. So having this in mind, there seems to be a delay in the enforcement of sanctions and also a gray area or uncertainty around how to implement the sanctions. And this is to be the case in the business world. And this is due partly to the lack or the delayed regulatory framework being updated. So that is in itself an issue.
Yes, what I've placed on the screen, so you can see it, is an example of exactly what you're referring to, Stephanie. This is one of several guidance notes published by the Law Society of England and Wales to help solicitors in private practice, or in the public sector for that matter, to deal with the implications of the UK's sanctions imposed on Russia. So it's a guidance note entitled Sanctions on Russia, Answering Your Questions. And it offers, not only does it offer a written overview, but it also draws the attention of solicitors to the Practice Advice Service, which is a confidential telephone-based helpline for solicitors. And there is, through this page that I'm showing you, an example of the systemic infrastructure that exists to help practicing solicitors cope with the many practical implications and problems that have been caused by the imposition of sanctions on Russia. I'm not a member of the Cyprus Bar Association, but the Cyprus Bar Association, subject to having appropriate funding and other mechanisms of support, they need to have mechanisms such as this put into place on a routine basis to enable lawyers in Cyprus to deal with the implications of sanctions. And as you can see from the official State Department statistics that I produced, Cyprus is going to be hit more than perhaps many other countries in the EU by those sanctions and the legal implications of those sanctions.
Thank you, Klearchos. Yes, I mean, I also follow the Law Society's guidance on a daily basis. I get their digest, and by the way, anyone can actually subscribe to their daily digest. It's a very helpful information, not only for professionals. It's very helpful information for citizens, any citizens who is interested in the proper administration of justice and ethics and integrity in life. And I was also very interested in actually seeing that in some of the daily digests and newsletters that we get, specific law firms in the UK, or in England and Wales at least, are named are named as not doing enough in terms of, implementing the sanctions against Russia, for example. And this is a naming and shaming game that seems to be actually quite usual in England and Wales. So that is a role, the supervisory role of the regulatory body or the professional body that is actually very interesting and perhaps worth looking at.
The other thing that the Law Society of England and Wales has been at the forefront of doing in this unpleasant climate that we're in now is to stand up for fundamental principles.
Yes,
it's
clearly.
all very well to impose financial sanctions upon an individual, but that individual may be entirely innocent, and that there is a tension between, on the one hand, the willingness of the law enforcement authorities in, for example, the United Kingdom to appear tough on Russia, and on the other hand, the necessity to protect the presumption of innocence. So the Law Society has been at the forefront of reminding everybody that the presumption of innocence and other fundamental principles of fairness continue to exist in austere climate. Another very important feature of democracy that is at risk in this current climate is the ability of every single person to obtain legal advice and legal representation. We remember from the Nuremberg trial that the most heinous people on the planet were given legal representation. And that principle is as applicable to an alleged Russian kleptocrat as to anybody else. The alleged Russian kleptocrat may be an honest businessman or woman who's made their money in lawful and fair circumstances. This is a problem that we have in this current climate, and the media is tarring the brush of guilt impliedly upon various people who have not been found guilty in any court of law. And the Law Society has been quite rightly at the forefront of trying to protect the traditional role of the lawyer. And this has relevance to your discussion on populism, because it's very easy for populist movements to engage in what we might call mob rule, or ganging up on a particular person, particularly through these new modern methods of communication, these Twitter campaigns and Facebook campaigns and so on. Somebody may be entirely innocent, but be on the receiving end of a barrage of online criticisms that are entirely unfounded or defamatory, or both. They would be defamatory if they're unfounded. So we need to be very careful not to throw away traditional principles amid this climate that we're in. That isn't to defend Russia or Russia's illegal conduct, or to defend any war crimes or crimes against humanity or other international crimes being committed.
Yes,
very important that we have sight of our traditional values. And there was an interesting question in the...
There is, but I suggest that we actually, because it's a long one, it's more like a comment from Dinesh, and it brings us back to some aspects of populism and corruption in India, so that's very interesting. I suggest that we keep that comment for later, or perhaps, Klearchos, you can put something in the chat for Dinesh, because we have come to the end of this first session. So I would like to thank everyone, particularly Klearchos, Andreas, and everyone for having listened, and for, I hope you learned a lot. I'm quite sure that you did. It's now close to 11 Cyprus time. So if we could give everyone a 10 minutes break, and please return with 10 minutes for our next speaker, Vasil, who's already among us online. Just to remind everyone to keep your cameras off.
And you shouldn't leave the group.
No, don't leave the group. Just stay connected. Everyone stay connected. We're not going to stop the recording either. And we will just reconvene in 10 minutes from now.
Okay, thank you for your attention and
thank you,
your
Claire.
questions.